Hello, thank you for clicking on the link. If you were feeling a bit lonely, that's probably why you've clicked on the link. My name's Charlotte McMurtry, and this is my colleague.
Rachel Templeman. I almost forgot my name then.
Um, it's been a long, however many weeks we've been in isolation, I think. We were having a conversation this morning, Rachel and I, just following on from the guidance note that we as a team put together. That's the landlord and tenant guidance note. And out of our conversations, we thought there was some useful information that we could share with you. And rather than write it down, we thought, why not tell you in person? So you can see what we actually look like, and we can do something slightly different. Days are long, days are very long. So we're obviously really conscious that whoever could be watching this, you could be landlord or you could be tenant. So there'll be some things that we have information-wise which are not that helpful for you, depending on which side of the divide you are. And yet there are some of you who are probably landlord and tenant, so there's some useful information. I think what I would say is that these things are not set in stone necessarily. Every case is different. So if you've got any queries, it's probably best to, this will give you an understanding of what's what, as will the guidance note, but it's probably best just to have a chat with someone. And we're very happy to have a chat with you. So, Rachel, what were we talking about this morning? Forfeiture was our first one, wasn't it?
Yeah, so I think most people are now or should now be aware that the government have imposed this moratorium to stop landlords taking forfeiture action against business tenants who are unable to pay their rent. So ordinarily where a tenant isn't paying the rent to the landlord, that would be the landlord's most likely course of action because it's the most serious and most effective. But that's just not on the table at the moment, and that has been suspended until the 30th of June. So we were thinking of what other options are available to landlords in the interim to try and preserve their rights to recover that money until the 30th of June at the time. So it's worth mentioning that obviously Section 146 notices for breaches of lease that are nothing to do with non-payment of rent, those can still be served, and you can still commence proceedings for forfeiture action based on non-payment of rent breaches.
Things like repair or
yeah, exactly. I mean,
something like that.
How likely the court are to deal with it is, well, it's not very likely, is I think the message that we got from the court. So they've listed priority 1, priority 2 cases, and funnily enough, none of those are taking back commercial property. So even if you do serve the notice and commence proceedings, you're probably going to be way down on the pecking order. So with that in mind, our other options that we were discussing are, hand over to you.
Oh, thank you. Commercial rent arrears recovery. It's called CRA, snappy little title. And basically that allows you as a landlord to go and uplift goods to the value of the outstanding sums. There's a formal process to be gone through. So it's not a sort of nip in, whip away some chairs and out again, which will be a relief to those of you who are tenants. But it is a formalised process that the High Court enforcement officers deal with. So whilst it's there in theory, and it's a good remedy for those of you who are tenants, there is some good news in relation to this, because although the applications can be made to the enforcement agencies, and they are still open, they are only processing the applications as opposed to actually going out and doing anything with them. All of their personnel, on the ones that we've been dealing with and the ones that we've looked at, they're all observing the lockdown, so nobody is out and about serving any notices. So whilst it's there as a remedy in normal circumstances, it is there ready and waiting at present. So no action is likely to happen under a CRA route for recovery of rent.
Chairs
we did look at some chairs are safe, yeah. We did, because there's a big market for chairs. We've heard a big underground market for chairs. We did look at some other mechanisms that for those of you who are landlords, you might want to think about. And it's also important that you, if you have assigned the lease to somebody and you entered into an authorised guarantee agreement, that you're aware of this particular remedy under Section 17 of the Landlord and Tenant Covenants Act 1995. Do you want to give a bit of information about that, Rach?
Yeah,
No,
so you
I
can serve a
don't.
section. I don't feel like that was an option. You kind of put me on the spot there. I don't- So you can serve a Section 17 notice. This is if you have a former tenant who you have managed to keep on the hook by way of entering into an AGA. No cooker jokes, Charlotte. That means that you can serve notice on them and ask that they pay the rent instead of the tenant if the tenant has failed to pay the rent. So you can recover up to 6 months of rent. So the idea is that you'll be serving the fresh notice every 6 months, and your normal debt recovery procedures would apply once you've served that notice and they've failed to make payment. So it's just another remedy if you've got that third party on the hook.
And the other one to be aware of is under the snappily entitled Tribunals, Courts and Enforcement Act 2007. This is the ability for a landlord to serve a notice direct on a subtenant. So if we've got landlord, intermediate landlord, and then subtenants underneath, if you have the ability to use the commercial rent arrears recovery system, so that's CRA, against your landlord here, then you as landlord up here are able to go to the subtenants by serving a notice directly on them and divert the funds from the subtenants to you, which again is all great in theory, but that's the presupposition that the subtenant actually has some money. But we remain optimistic. You never know.
Yeah.
There could be some people who are in a particularly great industry at present, and online stuff is where a lot of trade is happening. So it may be a viable option that a subtenant is in a better position than the tenant is.
Yeah, and it's about serving the notice and exploring your options against any possible person that might be able to pay the rent, so that you can get that money back some way or another.
Mm-hmm. The usual insolvency remedies are available, so that's the service of a statutory demand. If that is unpaid after 21 days, then that is considered in an insolvent situation, so you can proceed to winding up. There is talk amongst insolvency colleagues that there will be some kind of moratorium placed upon winding up petitions. I'm not sure of the current status of that, but we can update you with that as and when we know. I suppose you've got to think about what is the end game here. If it's you simply want to get the rent paid and the tenant is in a difficult position but expects to be trading once we get through this pandemic, then looking at insolvency options really doesn't help anybody. But it is an option. I
In
think
an
what we're
ideal
seeing.
world,
Sorry, Rachel. Yeah.
sorry, I was just going to say, in an ideal world, if you've got a rent deposit, then that's great. You can draw down from that. That's another option, and you will explore all of the other options before you proceed to insolvency, because that is very much a final course of action. And if your tenant's not able to pay because they're not trading very well, then once this is all over, if they're still not trading very well, how likely is it that you're going to be able to fill that unit once they are gone? I suppose that's the thought process that landlords have to be going through.
Yeah. This is a more holistic view is required of how the steps that you take at the moment will impact upon you as a business. And so one final thought that we had was just a word of warning, really, when you're negotiating any changes to the rent payments or the rent values, they will exist as a variation to the lease. So you need to be clear, if there's a guarantor, that that they are included in any variation. And also you need to be clear whether or not you can do this without falling foul of your own covenants, say to a lender, something like that. So there is a lot of there is, that's appalling grammar. There are a number of potential consequences to the course of action that you may take. So I think, as we said using the royal we there, I think it was me, said at the beginning of this, these are the various options that can happen, that you as landlord can take, that you as tenant, subtenant may find
Should be
yourself.
aware of.
Yeah. Every case is different. So if you are concerned or you are not sure, then please give us a ring and we will try and help you get to a situation that makes the best of this bad job, really.
Yeah, and there's a whole host of information and resources on our website from our team specifically, but also from other teams in the firm. So definitely check that out as well. New content all
Well,
the time. Love
well,
it.
if you've made it through to the end of this, then very well done. Hope it's been useful. And best of luck, everybody. Take care of yourselves. Bye.
Bye.